Am I mistaken?
I believe you're right, Chief Justice. The defendant applied for further appellate review, so as I understand it, I argue first. Good morning. Karen Swenson. If it may please the Court, Karen Swenson on behalf of the defendant, Milton Costa. The outcome of this case determines whether, from this point forward, all anonymous 911 cell phone tips will be considered reliable simply because technology allows the state police to identify a phone number from which they believe the call was placed.
But isn't the question in part whether this was an anonymous call?
I believe it is, Your Honor, and it's our position that it was anonymous.
Well, the phone number was there evidence that the phone number could be traced?
There was evidence that there was a phone number. There was no evidence presented about how it could be traced to a specific individual.
But was there evidence that it could be traced, not how, but that
there was no evidence about what the evidence that was presented was that the state police 911 phone system attributes a phone number to the person calling in. So, and in fact, the state police operator who testified at the second evidentiary hearing specifically corrected a reference to the system being called a phone trace. She clarified that it was in fact a caller ID system, a number identification system. And I suggest that there is a significant difference between having a phone number and knowing the person who is placing the call. The central issue presented by the appeals court and as argued by the government is whether that number makes this caller, this anonymous caller, identifiable.
Identifiable when? Identifiable at the time the call is made or identifiable in the future?
I believe that whether that person is identifiable at the time that the call was made, but I suggest in this case this person wasn't identifiable in the future either, based on this record.
But can I ask you this question?
Yes.
What if the operator had simply asked, ma'am, could I have your phone number, please? And she said, oh, my phone number is 617-534-2229. Right? Different case? Same case? Now we do it electronically. We don't have to ask. But what if she'd asked and it had been given?
I suggest in that circumstance that person would still be anonymous without more information. However, it would be somewhat different in a consideration of the fact that that person perhaps didn't have the same wish for anonymity that the caller in this case clearly did. I'd suggest in Your Honor's hypothetical that that person would also be anonymous because based on the record that we have here.
But has she placed her anonymity at risk, I guess is the right phrase, such that she warrants more, her reliability can be, well, she warrants more reliability. It's an indicia of reliability that weighs on that scale.
I suggest that she has not placed her anonymity at risk. And the reason for that, based on this record, is there's a very different circumstance when, like in the appeals court cases of Commonwealth versus Cox and Commonwealth versus Love, where there's a face-to-face informant, or in the situation even of Commonwealth versus Barrows, where there was a face-to-face informant.
What difference does that make if you don't know who the person is?
I'd suggest that the person is not identifiable. They're not accountable. If you can't say, this is the person who placed the call from this number, specifically where, or particularly where it is a cell phone.
But isn't it a question of what the person making the call thinks about whether or not she's traceable or identifiable? And as I understand from this record, that she heard that they had her phone number because she heard them repeat it. She was told twice that her call was being recorded, so they would have her precise words and precise voice. She told them exactly where she was at that moment because she identified the precise location of the defendant, said that she was standing right there, right then, and seemed to express concern, at least subtext, that the defendant would be aware that she was the one making the call. She was that close. So does she think that her anonymity might be at risk? She certainly seems to think that when she expresses concern that the police not show up right away.
I suggest that what the record supports, and in fact her call, is that she doesn't want to be at risk. And because of that, she's rushing to get off the phone.
But she knows she is.
Then she's on a cell phone. Correct. She's standing next to it, and she says, "Please don't come," because I assume she's looking around, or I can infer she's looking around and saying, "I'm the only one that's not on a cell. I'm the only one that's on a cell phone." I don't think that she's expressing concern, as sometimes happens with anonymous tipsters that they want to disappear and never have anything to do with it. My sense from this is that she didn't want to be identified in front of that person right then.
I suggest, Your Honor, that she doesn't want to be identified. There may be a lot of reasons why somebody who's making an anonymous tip may not wish to be identified. And in this circumstance, she expressly stated that she did not want to be identified, and she made sure she was off the phone so that she wouldn't be identified. She didn't leave her name and say, you can call me back later.
You know, it was interesting. She was never asked her name. I thought
She
that was
wasn't ever asked her name.
curious.
She was asked further follow-up questions pertinent to the tip she was giving, specifically, what really did you see other than this description and what you thought might have been a pistol? When asked, what type of gun was it? Did you see anything more? She said, look, I'm not going to get that specific. I saw what I saw, and I wanted to let you know, and then essentially hangs up on the operator.
But wasn't her reliability further bolstered by, she gave a description of blue jeans with red trim, which isn't all that common. And the police found a person of the approximate age that she described wearing, lo and behold, blue jeans with red trim.
I suggest the court in Florida versus JL address that specific issue. When somebody gives descriptive information that describes what a person is wearing, what the person looks like, that type of detail identifies the subject of the tip. It doesn't identify the criminal activity. There's no detail about any specific criminal.
It's innocent information. That's correct. But doesn't it add somewhat to her reliability?
I suggest that standing by itself does not. And I suggest in this case that's all we have. We have a police officer who heard a tip that RP was anonymous, that there was an individual, not even a race described, no height described, like in the circumstance of Commonwealth versus Barrows. We have a caller who says, here's this person who is a teenager, she thought. We know from the record that, in fact, the defendant was not a teenager, was over the age of 21, that is wearing jeans, a black T-shirt, and a red baseball cap. There's red trim on the cap and on the pants. That I saw when he lifted his shirt, I saw a gun. This isn't a circumstance where the officer received a report of somebody waving a handgun or that there was a fight going on or anything such that would indicate that there were perhaps exigent circumstances. This was a bare-bones tip of, look, there's a kid with a gun. I suggest that the officer arrives at the scene.
I suspect,
Yes.
to go back to Justice Costa's, Justice Cowan's question, is it's not just a bare bones, because from the point of view of the state, you have a tip, you have a location, a very precise location, not I was just driving through, we've had one of those cases, I was just driving through this neighborhood and I saw somebody drive past with a gun. A very precise location. You have a very precise description of a person at that very precise location. Why isn't this like Justice Kennedy's concurrence, which says, you can decide, but there are all kinds of other things that go to reliability that buttress this telephone call?
I'd suggest that, as a practical matter, this person was not identifiable. We have somebody who says, I'm at the park. We're presuming the reliability to even begin to assume that that's correct. She says she's at the park. When the officer arrived, she was not on the phone. There were 60-some people in the area, the record reflects. There was no evidence that this person was attempted to be contacted. This is not like the circumstance in Commonwealth versus Stout, where the person shouted out their tip to the police. People in the area overheard the tip shouted out. Yet, in this case, there was nobody who could have confirmed that they saw so-and-so on the phone. This person was apparently making a call, not wanting to be recognized, for a variety of reasons that somebody might not want to be recognized. In hindsight, we know, yes, a gun was recovered. Can
I just stop you right
Yes,
there?
yes.
Is the recording working? It's recording. That's fine. As long as it's recording, I just need it to record.
If I need to speak up, I assume
No, we
somebody
can
will
hear
tell me
you,
if I
but
do.
as long as it...
This is not the circumstance like a citizen bystander who happens to not identify themselves but could be identifiable. This person was not identifiable. This person was not accountable. There is, as we know, a gun recovered in this case. But it could just as easily have been in these circumstances that a gun was not recovered in this case. And then the person would have had no redress for their Fourth Amendment and
Well,
Article 14.
Think about that. Then perhaps that would have been the false filing of a criminal complaint. The police would have the number from which the complaint came. They surely could find out the owner of that number. and conduct an investigation. That's pretty specific.
I'd suggest, Your Honor, though, that leap to find the owner of the phone is something that's not in evidence. There was no testimony about how that could happen.
Well,
This is a
does
private...
there need to be testimony that if you have a phone number, the police can find out who you are?
I'd suggest there is in this circumstance, particularly where it's a cell phone.
Owns. I'm sorry. You don't know who's on the phone, obviously, but we can't just take judicial notice of the fact that if the police department has a phone number, they can identify the subscriber of the phone?
I'd suggest that in today's day and age, you can't just assume that. And that's specifically what's missing in this case. Perhaps if there was evidence to that point, the court could make different findings. But I suggest the Commonwealth is asking the court to assume facts that aren't in evidence, as the appeals court did in its decision. This is not like finding a license plate number where there's a computer access available. We all know that the officers can find out who owns a car, for example.
I hate to tell you that is not a helpful argument because, one, it's probably easier to find out who owns a telephone number, and two, somebody else could be driving the car.
Well, I'd suggest with a phone, it's just as likely. If there was testimony at the with the phone, it's just as likely that somebody else was using the phone. The circumstances...
But the owner could still say, I lent my phone to the person sitting next to me and describe the person.
They could or they could not. We don't know on this record whether that person would have said that, and this is what makes this case different from, for example, Commonwealth versus Love.
But it's not what they could do. It seems to me it's what she would have thought in terms of how far at risk she had put her anonymity. And it would seem to me that once somebody knows the phone number you're calling from, and you know they know it, it might not be certain, but you certainly know that if they really want to find you, they probably can.
I'd suggest that, first of all, with this reasoning, therefore, every phone tip is now reliable with that reasoning, because every phone to the state police, the phone number is recorded.
Well, no, but it's not always. It was repeated to her. She was told she was herself, her own voice was being recorded. She's told that twice. She gives them her exact location. Why would she still think she was anonymous?
I suggest that the tenor of her phone call indicated that she believed if she hung up that phone, she would be anonymous, and that's precisely what the operator was encouraging her to believe. We aren't coming. We're not going to be there. We're not rolling up, with the language used in the phone call itself.
Well, surely she did not want to be exposed on site to someone that she had just informed on as having a gun. I mean, clearly that's an understandable desire. That doesn't mean she wished to remain anonymous or thought she was anonymous in some other context.
Your Honor, I'd suggest based on this record, we don't know if there was another reason why she wanted to remain anonymous. And frankly, Your Honor, if the gun hadn't been found, we wouldn't assume that she didn't want to be.
She says on the phone, if you pull up now, he'll know who's told you. Because literally, can't you infer from that? She was literally very close to the person with the phone. If you pull up now, he'll know that I have called you.
Well, I'd suggest, first of all, that's not what Judge Kern in the trial court found. Second of all, Your Honor, I would also point out that in the nature of a cellular phone, it's different than a home phone. First of all, in this day and age, you can buy prepaid cell phones. That doesn't identify you as the person who owns it. There's a whole host of issues that are not on the record below, which I'd suggest was the Commonwealth's burden to make. How you identify a caller based on a cell phone.
Why?
Because it's the Commonwealth's burden to show that their tip or this informant is reliable. And I'd suggest that in these circumstances, they did not do that. This is a situation of a cellular phone. In fact, the 911 operator said that it was her belief, and it was objected to the second time it was asked, but the testimony came in the first time, the people who wished to remain anonymous, in fact, she felt usually used their cell phone. I'd also point out that Justice Kern...
That's just telephone calls. That's not cell phones or landline phones, because anybody can use a landline phone, correct? I mean, if it turns out, for example, that the landline phone is the call box at Logan Airport, it's a lot less easy to find somebody than a cell phone.
I'd suggest that that's not clear from the record, Your Honor. How do we know that you could trace this phone number and find this specific person? If this was a prepaid phone...
What you know is that she has a cell phone because she's saying so. I'm standing right here.
Correct, Your Honor.
Is this your number?
Your Honor, a prepaid phone is a cellular phone. Cellular phones can be purchased with prepaid minutes that aren't, you don't have a subscription to a particular place where you receive a bill. You pay in advance. All of this are things that are not on the record below, but it wasn't the defendant's burden to make that record. What is on the record is that if this had been a three-way call, if it had originated from another phone and somebody else had gone between, the caller ID technology would not identify which person made the call. It would be the first call, not the second call. Also, there was testimony below about pirated phone calls. And I see my time is up.
Your time is up.
Thank you.
Thank you very much.
Thank you. I'll rest on my brief.
Thank you, Ms. Swenson. Ms. Langsam?
Thank you, Your Honor. Good afternoon. Jessica Langsam, appearing on behalf of the Commonwealth. And the issue before this Court, as the Court has identified it, is whether or not a citizen witness who calls to make a report of a contemporaneously witnessed event, a crime that she sees occurring, she hears two different state police, or a state police and a Cambridge police operator, tell her your call is being recorded. She waits until that call is transferred. She hears her cell phone number being repeated on the line. Whether or not the police can reasonably rely on that information. Obviously, Commonwealth's position is that it can, and that the police response, Officer now Detective Regal's response, in going out, conducting a pat frisk on the defendant, first feeling what appeared to be a cell phone, then feeling a handle, asks the defendant, what is that? There's no response. Within 10 seconds, he takes out, and he sees that it's a .22 caliber weapon. And the veracity of this caller is clear from not only do we have her cell phone number, which, as Chief Justice Marshall has pointed out, is really better information than a license plate, which can be traded, lost, stolen, moved from car to car. Police can get that subscriber information. They can find out what other calls they made. Even if the phone was borrowed, we can find out, okay, Betty, who did you lend your phone to that day? So
what if it were a prepaid phone?
I think a prepaid phone, that's a harder question. But
Well, you'll have to concede that it's possible that the police could not have tracked this person down, but that really isn't what's required.
with a prepaid phone, just as with a landline that goes to the call box at Logan Airport. That's true, that's possible. But there's never been any requirement in any of the cases that the Commonwealth has to show at the motion hearing how we trace the call or that we identified the person. In fact, the defendant cites in her brief the case of Love, where the driver of the car was ultimately discovered, but the person who actually went up and made the report to the trooper, that name was never disclosed. And that information, what I think was only discovered on the eve of trial, not information that was presented at the motion hearing. So not only do we have a cell phone number which is traceable, we also have a distinct kind of number of people in a specific location, as Justice Sussman pointed out. This is a person who is physically proximate to the defendant. She said, I can't talk too loud. And if Your Honor, when Your Honors have the opportunity to listen to the tape, she's saying he's right there at the corner. And the police could have gone to that location. Not every person of those 60 people is a woman. Found out, who's the woman? Did anyone see someone on a cell phone? Who's the woman who has a cell phone? And from a process of elimination, found out who made that call. So there are those.
Is the tape itself, and not just the transcript, in the record that's before us?
Yes.
Your Honor, yes, both of the tapes. There's an initial, that state police tape with the transfer to Cambridge, and then the Cambridge tape.
Okay.
And that actually exhibit list is included in the Commonwealth's record appendix.
So the bottom line really is that she put her, as the appeals court said, her anonymity at considerable risk here. And
Yes.
that's all you need. That makes you no longer truly anonymous tipster.
That's exactly right, Justice Graney. And this really takes it out of the context. This is not Florida versus JL, where you've got an unidentified, anonymous informant, a tip. There's no information in JL.
And it seems to me they distinguished that case pretty well, the appeals court.
Yes, Your Honor.
What else?
Distinguishing this case from Florida versus JL, I think one of the most important factors is that in JL, there is no information about how the person who made the call came by this information, how they happen to have inside information about JL. Just a black man standing at the bus stop wearing a plaid shirt with a gun. Here, as this has already been discussed here today, we know the woman says, I'm right here at the corner. She sees him. She's physically close to him, and she's making this contemporaneous report.
And the time, there was no time given in JL.
That's
and here we know that it was a minute and a half.
That's correct, Your Honor. The opinion in JL says the record does not reflect how long it took for police officers to respond. And Officer Regal said, as he was pat frisking the defendant at that time, so that was just within seconds, other officers then arrived. And his response was a pat frisk. It wasn't putting him on the ground. It wasn't a dozen officers surrounding him with guns. It was definitely proportionate to the danger it was presented, which, as this Court's aware, a teenager with a gun in a public park where there were people ranged from ages 2 to 50, families with young children, which is, as Justice Osmond's pointed out in the concurrence in Barrows, that's a dangerous situation, a teenager with a gun.
Thank you, Ms. Langston.
Thank you.